Hey there. Today, we're diving into a decision that can completely sink a legal case in Ontario right from the get-go. Picking the right court. It sounds super basic, I know, but as you're about to see, one wrong move here can turn what looks like a sure win into an absolute financial nightmare. Okay, let's jump right in with a scenario. Let's say you're owed 30 grand. Now that amount fits perfectly in small claims court. But maybe you hesitate. Doesn't the Superior Court of Justice just sound bigger, more powerful? It's a really common thought, but trust me, following that logic can lead you straight into a trap. The best way to think about it is like this. Small claims court is your reliable, everyday sedan. It's built to be efficient, the process is way simpler, and it'll get you where you need to go without costing a fortune. The Superior Court? That's a massive, heavy-duty transport truck. It's built for these huge, complex cases and runs on a much, much more complicated and expensive set of rules. I mean, you wouldn't take a transport truck to the corner store, right? Well, the legal system is basically designed with that same logic in mind. All right, so let's get into the first big idea here, the general rule. The most important thing to get your head around is that these two courts are designed, on purpose, to operate in completely separate worlds. So that giant transport truck we were talking about, the Superior Court, it comes with this massive, super detailed instruction manual. And that manual is called the Rules of Civil Procedure. This is the complete playbook for absolutely everything that happens in the higher court. It's like the court's really complex operating system. And here it is, the most important part, right from the rulebook itself. Rule 1.02 makes it perfectly clear. The complex rules for the big court simply do not apply to small claims court. This isn't just a suggestion, it's a hard line. The system builds this wall between them on purpose to protect that simple, streamlined process that makes small claims work so well. Okay, so that brings us to our next point, crossing over. Because like any good story, there's a little twist. That wall between the courts, it's not totally solid. There's this tiny, very specific gate, but you need a special key to open it.
So you're probably wondering, right? Can you ever take your small claims case and get it into the Superior Court's lane? The answer is yes. But, and this is a big but, you don't get to make that decision yourself. You have to ask for permission.
So how do you actually do it? Well, Rule 1401.01.1 lays out a three-step process. First, you have to admit right up front that, yeah, your case belongs in small claims. Second, you have to file a formal motion with the Superior Court asking for leave, which is just legal talk for permission. And third, and this is the real kicker, you have to prove to a judge that it's in the interest of justice to hear your case in their court. And literally, everything hinges on that one little phrase, interest of justice. This isn't about what's easier or better for you. This is an incredibly high bar to clear. You'd have to argue something like, your $30,000 case could set a massive legal precedent for thousands of other people. It has to be about way more than just your money. Getting this kind of permission is really, really rare. It's the exception, not the rule. And this is where things get really serious. Let's talk about the financial trap. Because trying to get around these rules doesn't just waste your time. It sets a brutal trap where a simple mistake can cost you everything you were trying to win in the first place. So let's just play this out. Imagine you ignore the rules. You file your $30,000 claim in Superior Court, you go through the whole long, expensive process, and you win. The judge says you're right, you get your money, champagne's on ice, right? Well, not so fast.
And here it is. This is the trap spelled out in Rule 57.05. This is the rule with some serious financial teeth. It says that if you go to Superior Court and you win an amount that could have been won in small claims, the judge can order that you shall not get back any of your legal costs.
Let's be really clear about what that means. Legal fees in Superior Court can easily hit tens of thousands of dollars. So you could win your $30,000 claim, but find yourself on the hook for, say, $40,000 in your own lawyer's bills. Your victory just turned into a $10,000 loss. Ouch. And believe it or not, the financial risk doesn't even stop there. It can get even worse. For example, if you win just because the other side didn't even show up, your costs are automatically capped at the much lower small claims rate. And then there's the ultimate penalty. The court can actually order you to pay the other side's legal costs. Just think about that for a second. You win the case, and you still end up cutting a check to the person you just sued. It's wild. So what do we do with all this? Let's talk about the actual strategic decision here. When you boil it all down, making the right choice from the very beginning means understanding the point of the 3 key rules we've just looked at. So let's run through a quick strategic checklist. First up, the rule of separation. The courts have different playbooks for a reason. You gotta start in the right one. Second, the rule of permission. Just remember that crossing over is super rare, and you have to prove that really high interest of justice standard. And finally, and maybe most importantly, the rule of consequence. Getting this choice wrong can cost you so much money it completely wipes out your victory. So at the end of the day, it all comes back to that car analogy we started with. Choosing a court isn't about picking the biggest, most powerful option. It's about using the right tool for the job. A giant transport truck is powerful, sure, but if you just need to go to the corner store, it's the wrong and the most expensive tool you could possibly choose. So really, it all boils down to this one crucial question you have to ask yourself at the very start. When you're choosing which court to file in, are you setting yourself up for a real victory, or are you just signing up for a very, very expensive lesson? In Ontario's court system, the rules have pretty much already decided the answer for you.